What's up guys, Aaron Bennett here. In this video, going over the latest Celsius updates, here's what I'm going to cover. I'm going to talk a little bit about loans. I'm going to talk about FTX being possibly insolvent. I'm going to talk about the judge confirming Jenner and Block for the law firm examiner. I'm going to then cover the judge confirming the examiner's expanded scope. So that is looking into Cell Token. And also, did Celsius do things to lure people into the company illegally? Then I'm going to take a look at the judge approving Huron consulting for the examiner. The UCC and Kirkland agree to a list of stipulations regarding how they are going to store and protect cryptocurrency. I'm then going to go to a story about the judge denying a motion by an unsecured creditor to compel documents based on this Rule 2004. Then I'm going to take a look at the judge denying Daniel Frischberg's motion to compel insider clawbacks. The judge denies KERP, that key employment retention plan. The judge then denies Daniel Frischberg's motion to compel Celsius to institute cost-cutting measures. I'm going to explain why the judge did that. I'm going to go over the updated sale and bidding dates. I'm then going to go over Elementus, which is the blockchain forensics advisor for the UCC, how much they made in the last 2 months. I'm then going to cover the Celsius email that we got today, if there's anything important that you need to know. And after that, I'm going to mention Simon Dixon's video that he did for the judge to watch. So the first quick story right here from David Adler, basically talking about loans. They are speaking to Sean Owen, who owns Salt Lending. And the point of this is that if you have a loan, and if ideally Simon's plan gets put forth, there will be a home for loans. And there could also be some remedies to forced liquidations that happened as well. Next, taking a look right here. Basically, what's going around is FTX is insolvent because their balance sheet is highly made up of FTT token, which is their own made-up token, just like Binance has theirs and KuCoin has theirs. So if they needed to sell, there would not be enough buyers, so their balance sheet does not look good. And I said, hey, make sure you know this, UCC. If you approve them to buy our assets in a bid, hypothetically, this is very, very important. Next, taking a look at a quick story. The judge approves the appointment of Jenner and Block as attorneys for the examiner. So I just wanted to cover that. So they're going to help represent and assist the examiner, basically help prepare reports, and basically just help them out with their duties. So just kind of a basic story there. Next, order approving the examiner's motion to confirm examination scope. Now, this is important because this is, again, ordered by Judge Glenn, and what this says is that they are going to look into the debtor's Cell tokens, and also right here, made public representations to customers to attract them to their platform. So the examiner is now going to look into Cell token manipulation, and also if the executives or through their marketing materials were luring people into Celsius, maybe with illegal ways or by making false pretenses or all sorts of things like that. So that is very, very good. So I want to pause the video really quick, talk about iTrust Capital for a second. You're seeing the banners in my videos. This is where I have my Roth IRA, and this is a way for you to invest in even precious metals, but also about 50 altcoins, Bitcoin and Ethereum inside a tax-advantaged account. You can roll over an existing IRA, start a new one, roll over a 401k, and they even have staking available. So there's a link below. They're giving away $100 if you set up an account. Again, this is where I have my own Roth IRA, so I can take advantage of the massive growth of crypto and also do so where I do not get taxed on capital gains. I'll talk about this more in a future video, but there's a link below where if you sign up and you create an account, you will get $100 in Bitcoin. Next, the judge authorized employment of Huron Consulting Services as financial advisor for the examiner. So essentially, the examiner is putting together their team. They will help in the evaluation and analysis of any financial and valuation issues, interviews, examinations, preparation of reports, and other documents. So the examiner is a very important part of this process. This is the one who could potentially declare this a Ponzi, who could encourage the judge to say, hey, let's do a Chapter 7 liquidation. The next story is the UCC and the debtors agree to a whole bunch of stipulations regarding crypto privacy and also security and where they're holding our coins. So essentially, to sum this up, Celsius shall select an acceptable custodian. They can't transfer any cryptocurrency without permission. And why this is good is that there is just agreement. Things are moving forward. Celsius can't just do whatever they want with our crypto. Everything needs to be approved by the court well in advance. So next we have the judge denying a motion, basically compelling documents through the bankruptcy rule 2004. Now, this was done by someone like us, basically an unsecured creditor. I'll explain why this was denied. So essentially, this person was saying, hey, we need Celsius to provide documents that relate to whether it was insolvent in 2019, whether yields to existing customers were being paid with the assets of new investors, essentially a Ponzi, whether an insider took a loan in the period just before the petition date, whether account funds were commingled, whether the wife of Alex was selling t-shirts, and whether insider transfers were locked following the Celsius date. So that's what this person wanted Celsius to produce the documents to show. Now, the objection from Celsius is that the debtors argue that this person's interests are well represented in that the issues he raised are already being thoroughly investigated, and granting the motion would risk duplication of efforts. So the judge said that there is not good cause for him to conduct a Rule 2004 examination. The court has already appointed an examiner to investigate, and the UCC is already investigating, again, the acts, conduct, assets, liabilities, etc. of Celsius. The court said that these investigations are already happening again, and we wouldn't need to duplicate efforts and wasting estate resources. So the judge also says, to sum up, that we don't want unsecured creditors to launch their own discovery, given the burden and expense that will necessarily arise from such investigations. So I kind of agree. I mean, let's be honest, like, that would be like me being like, I demand Celsius to release documents. It's like, hopefully there are professionals that we're already paying from the estate's money that are doing that. And the judge does talk about there is a time and a place for the unsecured creditors to demand things like that, but there has to be a good freaking reason for it, and the judge does not see that right now. And speaking of the judge denying motions, so they denied Daniel Frischberg's motion to compel the debtors or the UCC to bring insider clawback actions. We have Daniel talking about in his initial argument Monero and how that could basically allow Celsius to hide assets. He wants to look into why they withdrew tens of millions of dollars in the days leading up to the bankruptcy filing. He asserts that the withdrawals were based on non-public info and that clawbacks are urgent because of the ease of which crypto can be hidden, laundered, and dissipated. The debtor, Celsius Kirkland, said that when the debtor in possession abuses such discretion, can creditors request the right to intervene. So they're saying that didn't happen, so you can't have just like individual people demanding things. This goes back to what happened before with the motion to compel basically discovery and getting those documents. Celsius basically says there are people already investigating these issues, like they have the examiner. And also the UCC disagrees as well with this motion. The UCC says that we need a more fully developed idea of what actually happened, and they say that any attempt by the committee to bring incomplete or insufficiently supported claims would be premature, potentially undermine future claims, and risk account holders' ultimate recoveries. And now the judge says that the concerns have merit, so the judge actually agrees that there needs to be some clawbacks, which is pretty interesting. The judge agrees it's important that the assets properly belonging to the estate do not leave the estate. So like with Monero, with money laundering, with sending money off into different wallets, and that assets have wrongfully been withdrawn from the estate are returned efficiently. But the judge does deny the motion, and I think it really comes down to what the UCC said about we want to do all of these clawbacks and prosecutions maybe when this bankruptcy ends. Essentially, these could take a long time, more money, and could delay the process, but we do want to look into this. The judge and the UCC agree that this is very important. Obviously, Kirkland says no, it's not, because they want to protect their own clients, but this will happen. It's just not the right time right now. So here, the judge denies the KERP sealing motion. So basically what this means is that Celsius wanted to pay $2.9 million to, I believe, like 62 employees, but they didn't want to include their names, their salaries, how much they were going to pay them, their job title. They wanted all of this information to be sealed. And the judge is like, no, it is denied. We are not going to allow you to do that. And if you want to resubmit it with basically allowing the court to see all this information, not everything needs to be public, right? But at least the court, the trustee, the UCC, they need to have all the information regarding who this $3 million is going to, because they want to make sure it is not insiders. So that is basically the summary of this article. Basically, hey, resubmit it with the ability for us to see into what's going on here, and maybe I will allow you to pay $3 million more to your employees. And again, this is to keep some critical employees on the team so they don't leave Celsius, they don't go to a better company with a better offer, because their argument is that there needs to be some documents produced, and there are some key functionalities of Celsius that would actually cost Celsius a lot more money if they had to go hire, let's say, like an outside advisor or a consultant. So actually paying $3 million to keep certain employees on the team is actually going to overall save the estate money. So next we have the judge denying, again, the judge is in a denying spree, Daniel's motion for an order compelling the debtors to institute cost-cutting measures. So the judge starts out saying, hey, we already appointed what's called an independent fee examiner. So this person's going to look into everything that we are paying all the advisors, all the lawyers, etc. The debtors, Celsius, claim that they are already reducing expenses. 70% of personnel costs have gone away. They've cut daily operational costs by more than 70%. So essentially, they've already instituted significant cost-cutting measures. Thus, there appears to be no basis for the court to override the debtor's business judgment. And here again, it says the debtors cannot pay non-ordinary course bonuses without further order of the court. We have Daniel saying, don't pay any bonuses, which I completely agree with. The judge here is saying, well, that's already enacted. They can't pay bonuses without my permission. And here the judge says the KERP motion was already denied. So the judge is being very careful with what money is flowing into employees' hands right now. So sorry, this is a little bit blurry, but this is the updated deadline for bids. We have the final bid deadline for retail platform assets, December 12th. So this keeps getting pushed out. Why is this getting pushed out? We need the examiner to rule on who owns the property, who owns the crypto, and is or is not this a Ponzi? Those are two of the biggest questions that would prevent outside bidders to want to bid on these assets, because who would want to bid on assets where we don't even know the property rights, and who would want to buy assets that could be a part of a Ponzi company in the future? So that's why they keep pushing it out. Hopefully this stuff gets resolved and they don't need to keep pushing this out any further. Next, we have the expenses for the blockchain forensics advisor Elementus from August 1st to the 31st. You can see here we paid them $311,000. So they work for the UCC. And then the following month in September, we paid them $200,000. So again, getting out of Chapter 11 is the most important thing right now. And Celsius sent an email today. Essentially, it doesn't really say much other than the EARN program is obviously paused indefinitely and stop sending money into EARN. They literally said, in light of this, we remind you that all users should cease transferring digital assets to Celsius. So that means people are still sending money into Celsius, which you got to stop, guys. More specifically, we remind you that automatic transfers for any accounts linked to your Celsius accounts should be disabled. So Celsius is still getting people's crypto. Oh my God, if you're watching this, please double check that you're not doing any automatic transfers. You make sure that it's not a Celsius wallet. That does not need to be said, but apparently they needed to let people know that's what's happening. And lastly, I want to cover a video that Simon Dixon made for Judge Glenn. Why Simon did this video is the last hearing showed that this could take a very long time to figure out all the different groups. If they rule on earn or stablecoins, then it could take another month or two to rule on custody or withhold or liquidated loans. And Simon's like, we need to bundle this together, and ultimately we need to educate the judge on cryptocurrency in Celsius. So he made this video for the judge. Highly suggest you watch it and also like it and even share it. The more it's shared, the more it's liked, the more attention it gets. I think that will be very, very helpful in this case. And Simon also showed this really cool slide. So essentially, he is enabling Bank to the Future to connect to your Celsius wallet and show you all the funds you have there. And from Bank to the Future, we can swap between coins and also equity. So they're building in this functionality inside of their Bank to the Future platform. So anyway, I will link the video below. Watch it, share it, like it, comment on it, because again, the more traction it gets, the better.